Straight ahead on Law&Crime Daily. The evidence-convicted wife killer Scott Peterson's family says he deserves a new trial over. Why a reported conversation between two inmates is now making appellate arguments.
If anybody ever deserved a new trial or to walk out, it would be him.
Unsuspecting motorists take the stand against a former Florida cop accused of planting drugs. How bodycam video unraveled more than 100 cases.
It's not mine, dude. I swear to God, it's not mine.
And 3 defendants in the Ahmaud Arbery case appear in federal court for the first time after hate crime charges are filed. Plus, a verdict in the killer roommate trial. An Ohio man admits the shooting, but does the jury believe it was in self-defense?
Yes, it was my fault killing him.
Law&Crime Daily covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm Brian Buckmire along with Terri Austin. The California Supreme Court has overturned Scott Peterson's death sentence, and he's now arguing for a new trial in the deaths of his wife Lacey and their unborn son. Angenette Levy is here to explain the evidence his family and legal team says could clear his name.
Yeah, Brian, Peterson has been on California's death row since 2005. The state's high court, of course, vacated that death sentence and said that a new sentencing hearing had to be held, but a new trial could also be on the horizon.
If there was ever a case that needed to be reversed on the guilt phase, that's the case.
Defense attorney Mark Garrigus represented Scott Peterson at his trial in 2004. He thinks it's likely Peterson will get a new trial and cites evidence in Peterson's habeas petition that could support his claims of innocence, including a 17-year-old conversation between prison inmates overheard by a corrections officer.
This Lieutenant Aponte recording where some inmates were talking about Lacey related to the burglary across the street, which was astonishing to me. Never in my career have I had anything quite that outrageous, whether it was coincidental, incidental, or not.
Garrigus said information about that call was not turned over by prosecutors until the day Peterson was convicted. Peterson's petition says a Lieutenant Aponte recorded the prison call between two brothers and then lost it. Peterson claims one of the men said his friend broke into a home in Lacey Peterson's neighborhood the morning she disappeared, and that he saw Lacey after the time prosecutors claimed she was killed. Police had claimed the burglary happened 2 days later on December 26th.
I would think generally, if you're going to commit a burglary, you're not going to do it when the world is watching on the day after Christmas across the street. And mind you, I've been there. We're not talking a large highway. This is a small residential street.
16 years after Peterson was convicted, his case is getting a lot of attention.
I think if people step back and look at the evidence, they're going to see this crime isn't solved.
2020 is taking an in-depth look at the case this week, with interviews from Peterson's sister-in-law, Janie, who's made it a mission to collect information she believes will exonerate Peterson.
There was information that I had that nobody knew or heard.
Amber Fry, the woman with whom Peterson was having an affair and testified at his trial, is also in the special. But the issue that may win a new trial for Peterson has to do with juror Rochelle Neese. Peterson's attorneys say she lied on her questionnaire about being a victim of domestic violence.
She did not follow the judge's orders. She basically said, I'm here to get justice for Lacey and little man, as she called Connor.
Now, the California Supreme Court sent this case back to the trial court and ordered the court to look into these alleged issues with that juror, Rochelle Neese. Peterson, meanwhile, will be back in court in June. Brian?
Thanks, Angenette. Joining us today is civil rights attorney Jeff Storms and Terri Austin. Jeff, late discovery handed over and potential jury misconduct, does that equal new trial in your eyes?
You know, a lot of times it doesn't, Brian. A new trial is a very difficult thing to obtain. But what I will say is that, you know, obviously this is a very factually detailed case, and the California Supreme Court has saw something about it that's raised its eyebrows. So I think that there's going to be a lot of attention placed on this case and a lot of facts to sift through.
Now, Terri, a new trial, but do you think that the new facts will create a new result here?
I don't, Brian. I think the evidence in the first trial was overwhelming, despite that most of it was circumstantial. I mean, you have the fact that Lacey Peterson's body floated to shore near where Scott Peterson was fishing. And that was no coincidence. And then we all know he had an affair with Amber Fry, and oftentimes that is also a motive. Having said all of that, Brian, I do think that if there is new evidence, we need to make sure that justice is done. And in fact, that issue should be determined one way or another.
Now, Angenette, what does the Peterson defense say about their chances on a retrial?
You know, they seem pretty hopeful. In all of the public comments that they've made, they believe that there were mistakes made in this case. I think it's important to point out, though, that the California Supreme Court, there were a number of issues raised in this petition that Scott Peterson's team filed with the High Court. And they basically dismissed many, if not most, of the issues he raised. But this issue with the juror, that's really come front and center. And Mark Garrigus said that this juror, Rochelle Neese, she was called Strawberry Shortcake by the media during the trial or after the trial. She was very flamboyant, very outspoken. Apparently, she's written a lot of letters to Scott Peterson at San Quentin, where he is on death row. So her behavior has really indicated to the defense team, or they believe, that she was not impartial and that she came in there into the deliberation room with a clear agenda.
Yeah. It seems that the new trial is the first battle that they've kind of almost laid some pretty good groundwork for. The question becomes, when they do get that new trial, what will the result be? Thank you, Evan, for your input. And now to Terri Austin with an update on the so-called doomsday cult couple case. Terri.
Brian, the defense is subpoenaing a local reporter and a family member of the defendants, ordering them to appear in court for the next hearing. Lori Vallow and her husband, Chad Daybell, are charged with concealing and destroying evidence while Vallow's children were reported missing. Authorities discovered the bodies of JJ and Tylee Ryan buried in shallow graves on Daybell's property. East Idaho News journalist Nate Eaton, along with Heather Daybell, the wife of Chad Daybell's oldest brother, are ordered to appear. They're due in court on June 9th for a scheduling conference. It's not yet known why the defense is subpoenaing either of them. Be sure to tune in into Law&Crime Network for live coverage. Brian?
Thanks, Terri. Still ahead on Law&Crime Daily, Ahmaud Arbery's accused killers appear in federal court for the first time. But first, hear from witnesses in the trial of a former cop accused of planting drugs, why they say drugs found in their car was not there before it was searched. Next. One by one, victims took the stand against Zachary Wester, the former Florida deputy who they say planted drugs in their car.
Did you end up agreeing to let him search the car?
At first, I was assisting to you. I said, you want to search this car? You search it, man. You know, search it all you want.
Okay.
You know,
why did you say that?
Sir?
Why did you say that?
Because I know that's their gateway entry. And I knew my truck was clean.
I saw what appeared to be a syringe sticking out.
Yeah.
Okay. Whenever I went, I looked further, pulled the seat apart. The syringe is actually in like a plastic, larger baggie with a plastic container with a substance in it that appears to be an illegal narcotic. Do you know anything about that?
I do not.
These motorists from Jackson County, Florida, have a similar story. They were all pulled over for a traffic stop by former deputy Zachary Wester.
That's not mine.
You use methamphetamine?
No, sir.
Cocaine?
No, sir.
Okay.
That's not even mine. I don't know where that came from. Possibly. I don't have a needle mark.
What is it that he just showed you, Mr. Driggers?
A needle that had foil wrapped around it.
All right, and we heard what you said. Just to be clear, what was your reaction?
Oh, shocked and nervous, trying to figure out what was going on.
Richard Driggers is one of those victims. Driggers says the headlight on his car was not working, but couldn't afford to fix it. Wester pulled him over, then reported smelling something suspicious. Driggers says he complied with the search of his car. The next thing Driggers knew, Wester approached him with this.
I got to figure out why you had the loaded syringe and the methamphetamine. Yeah, you know what that means when it's loaded?
It means you had stuff in it.
Yeah.
Yes, sir, but it's not mine, I promise you.
Okay.
Driggers was arrested and booked in the county jail. Many of the witnesses to testify against the ex-cop have one commonality.
Possible hot file hit.
A rap sheet.
You've never used methamphetamine?
I have in the past, but that's been a long time ago.
Like many others, Driggers pled guilty.
I knew nobody was going to believe it. That wasn't my stuff.
Why did you feel like no one was going to believe it?
Because he's a cop.
No, sir. It was my word against an officer.
Charges against Driggers as well as other witnesses were dropped. Back with us is civil rights attorney Jeff Storms and Terri Austin. Jeff, as I said earlier, the alleged victims in this case all seem to have those similarities that they have less of ability to fight back in court. Could Wester have been targeting them?
Well, I think that's entirely likely, Brian, and we see that all the time, right? I mean, often if an officer is going to engage in intentional, unlawful, improper conduct like they did here, they try to pick the easiest target they can, right? And typically that's someone who has a prior history, because that is going to likely impact their credibility right away if they have that prior criminal history. And typically someone with lesser economic means, because they're less likely to be able to hire an attorney or have access to the type of experts or legal defense that they might need to challenge an officer. So they certainly look for individuals who are on unequal footing with them in the system.
Yeah, and I have to admit, as a public defender, I've been here and done that, where your client is faced with take a misdemeanor in time served or sit in jail for another 2-3 months, where you can lose your housing, lose your work, lose all of this, and they rather take the $200 ticket and the misdemeanor to get out than fight the case. And I think that's what's going on here. Terri, the defense is pointing to the investigation and that the alleged victims could be lying, but with video like this that we're seeing in this case, is that a losing battle?
I do think it's a losing battle. I mean, if you take a look at Wester, the evidence against him is damning. His habit, the way he does each and every one of these individuals is all the same. He's picked these individuals, as Jeff said, who have a prior history or who may not have the funds to hire an attorney. And then he plants these drugs upon them. And then, you know, they are drug users from the past, but it's always the distance past. And he doesn't want to give them an opportunity, basically, to just go on a minor infraction. And all of these infractions were very, very minor. One had a cracked windshield. As you heard in the clip, there was a, light that was out. And then he says, can I search the vehicle? And of course, they may not know their rights, and they go ahead and let him search because they don't think there's anything there. So I think that all of this together, he does this each and every time. And the thing that I think is most offensive is he is in a position of authority and he's abusing that authority. And I think it's horrible. And I hope that, in fact, they do find him guilty.
Yeah. And I know this kind of crazy argument that I see in Minnesota that you're practicing in, Jeff, that some of these minor infractions, they should just be mailed in or checked in if you have the person's license plate rather than these stops, because this is a problem that they're seeing not just in this case but around the country. Thank you both for your input. Coming up on Law and Crime Daily, the verdict is in for the case of the dismembered roommate. Plus, the latest in the Ahmaud Arbery case, how much evidence prosecutors say they have against the accused killers, next. We're back. 3 men charged in the shooting death of Ahmaud Arbery are pleading not guilty to new federal charges. Arbery was gunned down while he was out jogging in February 2020. State prosecutors charged father and son Gregory and Travis McMichael with malice murder. A third man, William Rhodey Bryan, is charged with boxing Arbery in while filming the incident. They're now also facing federal charges for interference with rights and attempted kidnapping. Both McMichaels are also charged with using guns to inflict violence.
Just that.
Okay.
If he would have stopped, this would have happened.
That's fine.
The 3 men were arraigned in federal court in Georgia on Tuesday. They asked to be appointed public defenders. Prosecutors say they're prepared to turn over 1 terabyte worth of discovery, including FBI interviews, cell phone records, and search warrants.
Should we been chasing him? I don't know.
The defendants are due in state court on Wednesday for a motions hearing. Here to break down a terabyte worth of info in the McMichaels and Bryan indictment is civil rights attorney Jeff Storms and co-host Terri Austin. Terri, how do you feel the charges fit when you know all about the case, or what you know about the case? Were they undercharged, overcharged, or do these charges fit the acts?
I definitely think the charges fit the act. I mean, if you look at the video, there's no question that the father and son should be charged with malice murder. And in Georgia, that just simply means it was deliberate and it was intentional. And the fact that they chased him down, that was deliberate, that was intentional. They're also charged with using guns to inflict violence, and they used guns and they did inflict violence. And Roddy Bryan, I mean, he's being charged with boxing, Arbery in, and he did just that. We see that on the video. So I think all of the state charges are actually accurate, and the federal charges are accurate as well, because they did deprive him of his constitutional rights. No question about it. And attempted kidnapping, I think that makes sense because that's what they tried to do. So I think the charges are exactly right.
Now, Jeff, as a civil rights attorney, what does it mean to you to see these federal charges in 2021 with a terabyte worth of evidence?
It shows us that prosecutors across the country are becoming less afraid of pursuing these charges. These types of charges require, showing that there was intent based upon race, in this particular instance. And prosecutors don't like to lose, right? And so these types of difficult claims are the types of claims that a lot of prosecutors often wouldn't bring. But now in the current environment where we see Derek Chauvin convicted, right, of second-degree murder, I think it's provided more courage for prosecutors. And the terabyte of evidence shows us they're throwing their efforts more deeply and fully into this because they really believe they can and need to win.
Yeah, I can see that. There's definitely maybe a belief that these cases can be proven. I know they kind of steer away from hate crime charges or those involving race, gender, or other protected class. I think you're right. Hopefully we'll see more of this in the future. When we come back, the verdict. Did Michael Dixon murder, dismember, then burn his roommate's remains? We reveal what the jury determined on the other side of this break. Welcome back. After just 3 hours of deliberation, a jury found an Ohio man guilty of killing, dismembering, and burning his roommate. Michael Dixon was facing 13 charges for the murder and dismemberment of his roommate, Jim Whitaker. Dixon took the stand in his own defense and actually admitted to shooting Whitaker, but said it was in self-defense. Dixon claimed Whitaker pointed a gun at him first, trying to stop Dixon from leaving with his daughter. He said he burned the body because he was scared of getting caught. But on cross-examination, the prosecutor asked about allegations Dixon was sexually assaulting his 18-year-old daughter, the only charge he was found not guilty of.
You were having sex with your daughter, Melody, weren't you?
No.
So when Melody told that to law enforcement, she was lying?
Approach. Yeah.
Thank you, Michael. So when Keith Strickland testified that you and your daughter would go to bed together and there would be one bed down there, he was wrong, he was lying? Okay. So with respect to him saying that there were sex noises coming from the basement, that would not be true?
That's not true.
So according to you, James said that he was going to shoot you. Is that right?
That's what he said.
And then you decided to go and get your gun.
Yep.
But you could have left, right?
I could have, yes.
Okay, and you decided not to, correct?
I wasn't leaving my daughter there.
But James wasn't threatening you or your daughter. He was just threatening you, according to your words.
Yep.
Prosecutors then asked the defendant about allegedly trying to cover up the murder, like writing a fake suicide note in the victim's name.
My daughter showed it to Keith Strickland.
You didn't show it to him?
Nope.
That's nothing that James wrote, was it?
I don't think so. I don't know. I didn't write it.
Defense counsel asked you about your story being the truth now. Remember that?
Yes.
Just asked you that. Well, there are some things you said now that have been the first time you said them. You realize that, right?
Yes.
And why would you lead officers on a wild goose chase for this jawbone that you never had?
I don't know.
You lived in James's house for about 20 days after you killed him.
Yes.
And you sold his stuff, didn't you?
My TV, yes.
You didn't sell his gun?
Buying a gun, yes.
All right, let's bring in Jeff and Terri one last time. Jeff, convicted of all charges but the sexual assault of his daughter. Is that the verdict you saw coming?
Well, I think an acquittal on anything was a little surprising, although I didn't get to watch every beat of the evidence. But certainly after the testimony he provided in court, the convictions that we have were not surprising at all.
Now, Terri, it seems like Dixon's testimony in his own case didn't help him. Sometimes we say as defense attorneys, you can either, as a defense attorney, lose a case or the prosecution won the case. Where do you think this case fell?
I think it was both. I think it was a strong prosecution, and I think it was a very weak defense. Listen, if you just even think about the fact that Dixon lied so many times, the biggest lie was about how, in fact, Whitaker died. First, he said, oh, I don't know where he is. Then he said, oh, Whitaker left. Then he said, well, maybe he committed suicide. Then he said, yes, okay, well, I killed him. Then the other big issue, obviously, is that he covered it up. That's consciousness of guilt. The fact that he burned the body, it's just showing that he obviously is trying to cover everything up. He got rid of the individual's property. I mean, if you're selling the property, clearly you want to just make sure he's not in existence at all, and he hid the guns. So I think that the prosecution had a lot to work with. But here's one other thing, Brian. When Dixon got on that stand and he kept saying, yep, nope. It sounded to the jury, in my opinion, like he really didn't care, that he was cold and callous. And I think that's why he got the conviction on the highest counts.
Yeah, presentation on the stand as well as that cover-up. In just like 10 seconds, real quick, Jeff, do you think that cover-up really hurt the case for Dixon?
The cover-up always hurts in the case. I've seen this try to be done before. It never works, or hardly ever works.
Yeah, I mean, as the saying goes, sometimes it's not the crime, but the cover-up. Jeff, Terri, thank you very much. And thank you for joining us here at Law and Crime Daily. We'll see you next time as we discuss justice in America.